to this presentation on the OSHA Temporary Worker Initiative. I have placed online the agenda, and basically what we're going to be doing is covering these areas, giving you as much guidance as possible to let you know how it affects you, whether or not you are a host employer, and I'll define that, or you are a supplier or staffing agency providing employees to a work location, what your responsibilities are. The beginning of the agenda includes an introduction and discussion of the Temporary Worker Initiative, why it came about, what the issues were. We'll go there. Who are temporary workers? How do you know what workers to include at your site if you are a host employer as a temporary worker, and what, again, responsibilities do you have as an employer, as the host, to that employee, as well as what, if you are a staffing agency, what your responsibilities are. Go into the details relative to the responsibilities. Talk about employee and employer rights under OSHA, because this is the rights to every employee, whether they're a full-time employee on a company's payroll, or you are as a temporary worker based on the definition of it and the criteria. If that worker meets those details, basically, then he's your employee and you have additional responsibilities. We'll talk a little bit about health and safety practices. What is required? Why are they required? What's the importance of this? We'll go into some OSHA enforcement and guidance, and then finish up with conclusion, questions, and answers. As part of the OSHA enforcement and guidance, if I can get access to I may show you the web page OSHA has, the type of information that's there, and what assistance is available to you through the regulatory agency, through OSHA, and their contacts. Okay? So the question is, we talk about the Temporary Worker Initiative. What brought us to today? Now, let me paraphrase something. The issue with temporary workers has always been, quote, an issue with OSHA, as far as how they've been handled on site. But in 2008, with the major turnaround in the economy, downturn in the economy, a number of companies forced layoffs, terminations of people, because of what happened in 2008. When the economy started to improve, many companies did not rehire a number of the people that were trained and qualified to operate at the sites. They elected to go a different direction and they went to the staffing agencies and looking for increased number of people for staff supplementation for employees to fill the manpower needs, bringing people in who did not have all the knowledge and qualifications to operate the equipment, to work on the sites, but they elected to do it this way because it reduced their costs, and it was just a way of getting back to normal production. So in 2008, when this occurred, and then with the economy upturn in 2009, 2010, OSHA started to know that there was an increase in the number of workplace injuries, illnesses, and fatalities. Primarily, the concern was the drastic increase to what was classified as the temporary employees. OSHA asked why. Well, the answers were the new workers were at an increased risk of injuries. Why? Because the workers, again, were often new to the job site. They may have worked at numerous job sites on an annual basis for a week here, 2 weeks there, 3 weeks there, and problem was when they did get to a work location, they were not properly trained, did not have the direct knowledge. The staffing agency could not give them all the guidance and directions relative to health and safety, and apparently the host employers were not providing the essential information for the individual to perform the jobs in a safe and healthful manner. The temporary worker initiative was issued April 29th, 2013. And again, the memorandum highlighted the importance of protecting temporary workers. It also passed on additional instructions and guidance to OSHA personnel who were performing inspections when they went to visit the site, whether or not it was for a complaint, a target industry inspection, a fatality, or whatever else. They were directed to gather some information to identify if there were, in fact, temporary workers who met the criteria as far as responsibility of who would be responsible to the host employer. Look at the nature of their personal protective equipment, identify whether or not those individuals were working in areas that they were exposed to the hazards and risks that caused the fatality or caused the reason for OSHA to be there. Like I said, target industry, if it was a fatality, were there such people working in those areas, looking at how those people were trained, the nature of their personal protective equipment, and whatever. OSHA also, as part of the initiative, reached out to stakeholders. We talk about stakeholders would be the staffing agencies themselves. How are they preparing their employees who they are providing to a company? How are the companies accepting those people when they come in? What are they doing? How are they getting them prepared to do the job? How are they overseeing the activities on the job site? Looking at what employers, in these cases with stakeholders, interest groups that represented a variety of industries, how in fact were they providing that support to those employees? And looking and trying to identify who had good programs, what was the quote unquote, the best programs they saw that were responsible in reducing injuries. So again, like I said, the OSHA Compliance Directive required the compliance personnel to verify the presence of temporary workers on site, and if they were working within areas of the scope of the inspection, identify if such workers were exposed to the violative conditions or situations where the injuries could occur, review adequacy of their training, and also evaluate the appropriateness of PPE. Now, it just goes back, like I said, and OSHA started seeing this back in 2011, 2012, but the breaking point that really was the end of it, the straw that broke the camel's back from OSHA viewpoint, was an incident that occurred in the fall of 2012 at a Bacardi bottling plant, where an employee who was hired out of a temporary staffing agency came into work in the manufacturing floor. On the first day of the job, the individual was crushed to death when he was operating in and around a palletizer machine. When OSHA looked at, in response to the investigation of fatality, they found out that the employee, being on the first day of the job, was untrained on the plant procedures and specifically untrained and unaware of the requirements of the plant's lockout tagout program. The individual was positioned in an area and doing a task that, if he had the right information, should not have been doing it until it was locked out and tagged out, and it was appropriately done. And he did not have a proper oversight from the supervision, people who were overseeing his performance of the job, as to how to do it, and as a result, this fatality occurred. And then OSHA went back and looked and found that in other cases where fatalities occurred or serious injuries, hospitalizations, and they looked in more detail, they found, again, that was a common problem, that employees were coming on the job ill-prepared to do it, without the knowledge, without the direct supervision. So that was the point that broke the camel's back, essentially, and OSHA said, we need to move one step ahead. We need additional guidance to prevent these from happening and reduce the repetitiveness of these events occurring. The OSHA initiative basically was ensure that staffing agencies and host employers understand They understand the responsibilities under the OSHA Safety and Health Act. Many employers understand that, but in some cases, some smaller companies, smaller employees, single site operations, they didn't have all the guidance and knowledge. They never had much involvement maybe with OSHA and not knowing exactly what to do. Also to enforce and make sure that, again, temporary employees, workers, were entitled to the same safety and health protections as those employees who are directly hired and directly paid by the company, full-time company employees, so that they receive the same basic training, use the same personal protective equipment, and were aware of the procedures and programs in effect, I mentioned, including lockout, tagout, if there was confined space, electrical safety, whatever they were involved in, to understand those. And the initiative also intended to clarify that the responsibility was not solely on the host employer, but it was also on responsibilities were also on the staffing agency in certain aspects to ensure that the employees they were providing or sending to a site had some basic knowledge and understanding of the work tasks that they were to be performing. In many cases, that may not have been the situation with staffing agencies. So the Temporary Worker Initiative, the OSHA actions, promoting the compliance assistance nationally and locally, boning up the notification as to who they should contact at an OSHA regional office in one of the 10 OSHA regions of the country for the government. In the area offices, people who were responsible, who they could contact if there were questions in a local basis. And this would cover both OSHA state plan states would have to meet with these requirements and provide this information and accessibility to OSHA personnel, or if they were OSHA regulated states that they were operating at state plan, there was no state plan, OSHA's area offices would take care of this. Looking to identify the best practices, developing outreach material, guidance documents, examples, scenarios of information relative to how to implement certain programs relative, and I'll talk to those programs in a bit, and also show you where you find those that documentation on OSHA webpage and where you can find the information. I'll go through that. They met with national advisory committees, whether it was for construction, general industry, staffing agencies. They met with them to discuss how their programs and understanding how to better develop those programs to reduce the injuries recurring. Now, as I said, this was not something that OSHA was not looking at before, but it wasn't one of the things that you would consider to be, until this situation occurred, high priority, unfortunately. I mean, November 21st, OSHA did issue a clarification of OSHA safety requirements between the temporary staffing agency and its client. All right, they covered that. It was a temporary coverage until they had everything in place. They had, over the period of time, in fact, going back to the early 90s and into the 80s, they had issued letter of interpretations for various standards and various questions that were asked by industry. How do we respond to individuals who are provided to us through temporary agencies for supplemental staff supplementation? How do we deal with those people and how they should be dealing with it? Who was responsible? There was some guidance relative to record keeping. There was indications as training of questions that were asked by a variety of people, as well as hazard communication, for example. All right. This is just a statement when the OSHA implemented their initiative, from what basically summarizes what I just said from David Michaels, who was the OSHA administrator, the Secretary of Labor for Occupational Safety and Health. He reinforced that it was essential that both employers comply with all relevant OSHA requirements, staffing as well as host employers, and that the host employers are to be treat their temporary employees as they do their existing employees. All right. Now the question comes back: who or what is a temporary worker? Now, according to the Bureau of Labor Statistics, BLS, temporary workers are those who are paid by a temporary help agency. All right? They're being paid by the agency. But the basic as to whose responsibility they are for, as far as from the main safety and health issues, it comes back to the relationship to the company. They're paid by the temporary agency whether or not the job is temporary. For the purposes of the memorandum, temporary workers are those supplied to a host employer and paid by the staffing agency. But one additional feature comes in that was not included in this definition is the idea of who supervises that individual on a daily basis. And if that employee is hired, there's a differential there. You may look at a temporary employee as a contract employee, which is correct, but there's a difference between a contract employee and an independent contract employee. A person from a staffing agency who is supplemental labor, if they are being supervised daily by a company employee as to what their daily work tasks are, how to perform those tasks, overseen by a staff of a company employee, that is the responsibility. They basically would meet the criteria of a temporary employee who is the host employer has responsibility for and would be considered as an individual who is as equal to one of their own full-time employees. Unlike a contractor employee or independent contractor employee, you hire somebody to come in to do some plumbing, some electrical work, some pipe fitting, or whatever else, or welding of special equipment. You bring them in on a contract. They have their own management. They have their own supervision. You are only identifying a scope of work and a work task. They're doing that in accordance to whatever procedures or whatever is appropriate for the installation and repair of a system without your direct input. You may have some specifics as to how they need to do it or what equipment they need to use, but generally you are not providing the supervision on how they do their task, but rather they are receiving that from the contractor's employer. Contractee's employer. Somebody is supervising them. So that's the difference. The contractor is not independent in the case of the temporary employee providing supplemental labor to a facility versus an independent contractor. So whose responsibility are temporary workers? Are they the responsibility of the agencies hiring out the employees? Are they solely the responsibility of the host employer's responsibility? Or are both groups responsible? The answer is it's a shared responsibility. Both the host employer and the staffing agency are employers of the temporary worker, and both have responsibility to the health and safety of that employee. The difference is the nature of responsibility and the nature of information that will be provided to the employee. All right? So it's a shared responsibility. All workers must receive equal protection. Expectations are the host and staffing employees will contractually assign responsibilities. So when the staffing person, they agree to provide so many workers to a company, there's contractual arrangements, how they will build a company, how that person will be paid. It's responsibility of the staffing agency. But again, the basic responsibility is because you will be, if you're a host employer, your personnel are daily directing and supervising that individual. That responsibility causes them to be accepted and looked upon as being your employee. Okay? Consider which employee can best prevent the hazards and fulfill compliance with OSHA. Again, that's a shared responsibility. As I mentioned before, the staffing agency has some responsibility to make the person aware of some information as far as what OSHA is, what kind of programs they would need to comply with and be aware of. But again, those are going to be on a generic type basis, very, very general requirements. They get to the host employer, you have your specific procedures, protocols, programs, guidance, how to do the job, what PPE needs to be used, if it's above and beyond normal, routine, basic PPE, what is required and how to do the job. In the case of the Bacardi beverage facility, the question was, the individual came to work, was placed on the shop floor, was not informed that he should not be standing there, no, was not supervised, was told that if he was going to be working there, he could not work there while the equipment was operating, that it would have to be, if he needed to be there to do some work, it had to be shut down in an appropriate manner. He was not made aware of that. As a result, it resulted in a fatality. And then the other aspect is due diligence or verification that compliance has been achieved. The host employer has responsibility for that. And sure enough, I would say the staffing agency also does, because they need to verify that the employees they are providing, even though they don't have day-to-day responsibility, they do have some responsibility to ensure the health and safety of those employees, to make sure that their people are receiving the appropriate training and other types of equipment to do the job in a safe and helpful manner. Examples of shared duty, for example, for training. And again, the OSHA guidance documents they prepared for this goes into these things. Hazard communication. It's the right, every employer must provide some information relative to what a safety data sheet is, hazard communication. But they're looking at for what hazard communication standard involves. But again, it's going to be on a generic basis, very, very general information from the staffing agency's point of view. The person gets assigned and goes to work at XYZ grommet manufacturer, okay? And now they need to be trained on that point on the specific site programs. Who maintains the safety data sheet at that site? What are the hazards that they need to be aware of in handling certain chemical products or physical exposure issues and whatever else? What do they need to know? What are those hazards? Where do they find out how to identify as to what personal protective equipment, what work procedures, or whatever else? It comes back, the host employer needs to provide that detailed program to them. Lockout, tagout. Staffing agency can make people aware. Let them know if you're working on a piece of equipment, they tell you to do something to the piece of equipment. There's a question you need to ask if you're not aware of working it. Is there a lockout, tagout procedure? Is there a process that we need to work on to do to de-energize or shut down the machine? Just to give them the awareness. The host employer is required to provide this machine-specific and site-specific procedures for dealing with shutting down or de-energizing equipment before it's worked on. Emergency action plans. Basically, we're talking about evacuations in case of fire or other issues relating to a facility. The staffing agency can provide general concepts as to what the person can expect when they get to a site. You're going to need to know the routes of exit. You're going to need to know where you're supposed to go in the event of an emergency, where you're supposed to muster to. It's the host employers to provide this detailed information, what to do, who will be responsible for you, who you are supposed to check in with when you do evacuate and you end up at a certain point. And also issues like accident reporting. Because as you'll find out, as I said, the host employer, if you are supervising that temporary employee, you are responsible for any injury or illness that occurs on the job to provide medical, first aid, treatment, send that person to the hospital for the medical aspects, and also to report and record on OSHA logs. The staffing agency only needs to make sure that their employees are aware to check with the site when they get there to verify what do we do in the event of an accident if we get hurt. How do we report that? Make sure that's reported. And also, in some cases, the staffing agency should say if you have been injured, should report it back to us and let us know that a situation has occurred. So we're aware of it to make sure that you're getting the proper treatment again. And if you are unable to work, we need to know that, whatever, but that's the information. So it's a two-way street. Now, employers are required under OSHA rules, whether it's a staffing agency or the host, provide a workplace free of recognized hazards. Provide appropriate training in a language and vocabulary that the workers understand. And you cannot retaliate against workers who raise safety concerns or report injuries. Whether or not they're reported to their supervisor directly for such an injury or an issue relating to a potential safety and health concern, or if the individual has reported this as unsafe condition and nothing has been done and it persists, the individual has the right to file a safety and health complaint with OSHA or a state plan to require or request an inspection or notification of the employer of a condition that needs to be addressed. This also will cover that if the individual feels that because of, again, like I mentioned, they have brought these issues up, they are retaliated with, they are told don't come back to work, they are moved to a different position or whatever else because they filed these complaints, they brought these things up. The answer is they cannot do that. You cannot be retaliated with. You cannot be terminated because of this. You have protections. Employers have the responsibility to, at a minimum, meet the requirements of the OSHA standards, whether it's construction, whether it's general industry, whether it's maritime. It's the requirement. The OSHA standards are considered as the minimum standards that have to be met. Company elects to use other types of means to meet the requirements that exceed the standards, that's fine. But OSHA standards are the basic, what has to be met on a routine basis. And if there's a problem or issues occur, to correct those and implement whatever changes are necessary. Employers must perform due diligence to find and correct safety and health hazards. They see a condition or see a situation where they're getting excessive number of injuries in a certain area of the plant, of people doing certain operations, to investigate. Why are they occurring? What can we do to correct it? Is it a situation where we haven't trained the personnel properly, or we've changed the process and we have not updated our procedures, protocols? We need to do that, or we have some equipment that needs to be changed out because, again, it's creating a hazard and we have to find out how we can control that and change and modify that. The employers must provide safety training to employees in a language and vocabulary they understand. And employers must inform workers about chemical hazards, through training, the different type of labeling systems they may use to identify the nature of the chemicals, nature of the hazards associated with it, color-coded systems. In most cases, if you have a water line running through, it's identified. If you have a line running through with hydrogen, it may be color-coded. Or if it's an oxygen line, it may be stamped oxygen and labeled as such, but also it's a certain color. What the alarms are. Some organizations have a fire alarm. They may have an alarm for a shelter in place in case of bad weather or inclement weather coming, a tornado, a hurricane, that they have to shelter inside of a building to be protected. And there may be different types of alarms. If you're in a nuclear facility, there's going to be different types of alarms if you have a release of nuclear material. It's going to be different types of alarm systems and alarm sounds, but make sure people are aware of those things. Workers' rights, again, workers have the right to a safe and healthful workplace. They have the right to receive the information and training that's essential to them to do the job in a safe and healthful manner. And they have the ability to file a confidential safety and or health complaint with OSHA to have the workplace inspected. Does that mean if they file a complaint that the site's going to be inspected? Not necessarily. They may not receive an inspection. You may not, as a host employer, receive an inspection every time somebody files a complaint. OSHA may look at this as saying, this seems to be a rather inconsequential complaint. It's a safety issue, but we're not going to send somebody out to correct this or inspect the site. We're going to ask the facility and send them a copy of the complaint and ask them to review the issues, identify if there is a problem, and let us know what you are going to do to correct this situation. Failure to respond to that in a timely fashion, most likely you will get the knock from the OSHA inspection. All right. Workers also have the right to participate in an OSHA inspection and to speak with the OSHA compliance personnel. They have a right to file in the event that they have been discriminated against or action taken against them in some way, to file an OSHA complaint to respond to these, which again, it would be a notification to the site that they've received a complaint that an individual feels they've been discriminated against, or action has been taken, retaliation as to termination, failure to give the individual overtime, transferring him to a lower paid job, or whatever else. OSHA will notify the employer and probably go in and do some kind of inspection to verify and identify that these issues are possible. Also, we're talking about whistleblower. If the individual believes that the company is doing something against OSHA law, or there's a number of other types of laws, they have the ability to file that notice that they believe that there's something that's not being done according to the requirements of, and in the U.S. is under the Sarbanes-Oxley Act, which they may have some ethics issues. There may be some problems relative to reporting to the IRS or whatever else. There's a number of things. Under additional laws, which OSHA has jurisdiction to perform for different things like railroad, they do have responsibilities to review these complaints relative to airline industries, railroad, and a number of other organizations. Now, what are the appropriate recommended safety and health practices for both the staffing agency and for a host employer? The staffing agency and the host employers both should have some kind of a written program. All right. Again, the staffing agency is going to be rather general because you can't cover until you know what the employee is doing, what the basic hazards are, what you need to look at. You can cover the general, the basic safety and health requirements. Verify and understand for the individual as to in a written safety program, and to understand when they go to a job site, what type of personal protective equipment are they going to need to take with them? What is the general equipment? It might be safety shoes, steel-toed shoes, eyeglasses, whatever. And there's other things that may be required. It requires in the staffing agency and a host, primarily though this issue comes back more to the host employer, is perform a hazard assessment of the work site to understand and identify what the hazards are, what issues need to be addressed, is the severity of those potential hazards, and identify how you're going to resolve them to eliminate the risks and to remove them and take the risks down to from a serious injury or fatality, something that might be minor, to reduce the severity of it and reduce the frequency of that type of injury. I think a recommended safety practice, and this goes back to the initiative, is that when the contract between the staffing agency and the host employer is developed, Define the appropriate scope of work that defines the nature of the type of employees that the host employer is requesting of the individuals, as far as maybe qualifications, training, background, that may be specified within that contract. The staffing agency can put terms in. We need to be aware of certain aspects, or we need to look at your site. We've never been there. We need to come out and visit to identify what those issues are, what your hazards are, what you do at that site, so we can better prepare our people that we're sending to you, what you do, and they have a better idea and feel for what's going on. The need to conduct new project orientation and safety training that addresses hazards to which the temporary worker may be potentially exposed. And again, the primary responsibility comes back to the host employer. Unless you are a staffing agency who provides one specific type of employee for specific needs. For example, you may be sending people out to work with people who are doing excavation work, who are working at heights, maybe welders. You're providing that type of personnel. You may need to provide some more specific information to make sure the people that you have on staff, the people that you have for assignment, meets certain criteria and are aware of the hazards and other potential exposures. OSHA enforcement and guidance overview. All right. OSHA has the Temporary Worker Initiative. That was, and I'll show you that web link and website that has that information. OSHA has spoken to, like I said before, trade organizations, the staffing agencies. They've talked to a variety of host employers and organizations that represent various host employers. This could be chemical industry, professional trade groups. It could be American Iron and Steel Institute, whatever else. They talk to people who bring in and companies that hire temporary people, what they are doing. Again, the OSHA enforcement says that safety and health is a shared responsibility, and also provide information as far as how best to comply to meet the requirements and standards. One of the best places to start would be from a staffing agency. If you just want to see what type of the hazards that are most frequently or most common, you can go visit the OSHA webpage or do a Google search and ask for the 10 most frequently cited citations within OSHA. And it will tell you, you get this on an annual basis. They update this. And you can look into each one of these and find out what specific portions of the standard may be a problem. These are ways of identifying from the temporary agency, provide and ask questions to the host employer that you're not familiar with of the hazards and the problems, to identify what you need to do to how you can better provide information to make the person aware when they come to the site, and verify that the person, once they get to the worker site, the host employer site, have been trained and provided the appropriate information. They are overseen by senior personnel or experienced hourly employees on the floor to make sure that they are doing the job in a safe and healthful manner. But again, these are things. Now, from 2016, this was published, and again, some of these don't change that much from year to year, but these are the most common ones. Fall protection injuries, whether this is it's referenced as construction, it's also a problem within general industry and maritime. Hazard communication, scaffolding, and again, 1926 is construction, but there's a number of general industry people, companies that use scaffolding to build equipment that they're manufacturing, that they need to use it. The same requirements follow there. Respiratory protection, lockout, tagout, powered industrial truck operations, use of ladders, whether on a construction site or general industry, how to properly use them, electrical wiring problems, situations, electrical, machine guarding, and the general requirements of electrical safety. Some other areas that you'll see is very common might be confined space problems, maybe the failure to provide emergency action plans and evacuation information to employees. These are some other things that are common. But identify, and there's also ways, and in some cases, as a temporary agency, if you have a new company that you're going to be sending people to, you can actually go into the OSHA website and put the information in and look at the nature of inspections that a company has received and identify some of the citations and some of the issues that those companies have had. So you can do that as well to see if they match up with these. Recommended safety and health practices. The staffing agency should maintain, when you send a person to the site, maintain a communication route link. And tell the individual that your person to keep you informed what's going on, and to communicate with the worker and the host employer to verify that those people that you have supplied are doing the work in a proper manner, or that you're assured that certain training, and you ask for any and all, you can ask for any and all records of training for that employee for your files, so you know what the individual has been trained to, and it makes it easier for you to provide, in some cases, the appropriate type of employee that the site will require as far as training, background, or whatever else. Staffing agencies to ensure that injuries and illnesses are properly reported and recorded. Individual cuts his hand, temporary employee, what's he to do when that injury occurs? How is he to report it? How is he to get first aid? He needs to know that. The site needs to know that. One thing in particular, if an injury occurs, person fails to get medical treatment, it doesn't go on the OSHA log, who's going to be responsible for that? How to collect that information and make sure that when that individual reports an injury, again, like I mentioned before, there is no retaliation taken against him because the injury occurred, and an investigation into that event, the company has performed that record and notifies the staffing agency. So again, the staffing agency should be alerted to workplace hazards, so they may take appropriate actions to make sure that anybody that they send to that location in the future will have better knowledge as to what to expect. And verification that the scope of the work is being maintained. That send somebody to a host facility, yeah, because he becomes essentially a host employee, but you've sent the person over to do maybe general labor, and they have taken that individual, and he's doing something else. The question is that the right thing to do? What is the person doing? Verifying that what the personnel you sent over to them continues to meet their requirements, and or do you need to send somebody, replace that individual with somebody who's more qualified? So I think that's what you have to look at to ensure that. Injury, illness, record keeping. Who is responsible? Responsible to record work-related injuries and illnesses is based again on who supervises the temporary worker's day-to-day tasks. As I mentioned earlier, if he's a hired employee, staffing agency, supplemental employment, being supervised by a company manager, host company manager, supervisor, or other employee, that employee is yours. So if an injury or illness occurs on site under those conditions, it's the host's responsibility to record any and all illnesses that meet the OSHA recordability criteria on the company's, the site's OSHA 300 injury and illness logs. You can go back to the injury illness reporting requirements Under 29 CFR 1904, you can look at 1904.31, who identifies, if you have more detail as far as who a covered employee is, which does include the identification of the temporary employee. You can go back and look at OSHA CPL 02-00135, which is Record-Keeping Policies and Procedures Manual, which has a listing of questions and whatever else relative to record-keeping. You can go back to letters of interpretation that have been issued. There's many of them that have been addressed as to how a host employer is to respond to temporary employees, how they are to report. And again, the differentiation between a temporary employee and an independent contractor employee who is working at your site but is being supervised by the contractor's management, not by your personnel. All you are doing is giving them a work task. They are completing it according to the training and knowledge that the contractor and his staff and his workers will perform the work tasks. You may have responsibilities from a host employer working with a contractor to ensure that they're following your safety and health procedures as well. But again, how they perform their work task, you are not directly supervising on a day-to-day basis. And the reason why you need to look at it on a contractor basis, an independent contractor, if they're not performing the task in a safe and healthful manner, and you, as a host employer, I just pass this on, see what's going on, it doesn't meet your criteria, and injuries or events occur that result in serious injuries, fatalities, there's a possibility that as the host employer, having knowledge of a certain operation of a contractor on your site, not under your direct supervision, and allowing them to continue knowing that if a problem does not meet your criteria, does not meet the OSHA regulations, you may have some responsibility if there's an investigation under the OSHA record keep, under the OSHA training requirements. Training. Provide the appropriate safety and health training, ensure that the employer is also providing it. This is from the staffing agency and from the host employer. And as I mentioned before, the host employer mentioned, and I need to reinforce this, will provide the site-specific detailed information. Staffing agencies are, for the most part, are not going to have it. There are some exceptions to that where they have been held to when violations that they did not provide adequate training to the employee to do the job when they sent the person to it. So both the company and the host employer, staffing agency, may have responsibility. All training should be done or must be done before the work begins on a project or at a new work site. Individual, if he has no idea what he's doing, he is given the training, and then he may be working with, like I said earlier, a senior hourly employee, an experienced person, to verify and understand what he's doing before the task requires it. He has to meet certain criteria before he can do the job on his own without being directly overseen. So it needs to be done before. And hazard communication, like I mentioned, is an example of a shared program. However minor this might be, again, you as a staffing agency will only be able to do this in a very generic manner. The sites will have specific hazard communication programs, do everything relative to training, how you label your chemicals, how you label the hazards in the workplace, where the person can find the information, who is responsible, how they can access a safety data sheet, how they can access whatever information is there, and who they need to talk to. These are the things that the company, host employer, will provide. This is a situation here, a scenario, all right? A manufacturer of metal cans. They need machine operators for a short-term increase in production, all right? Bring people in from a staffing agency. In this case here, they bring 10 people in. The people they're bringing in don't have full knowledge and handling of the English language. So what needs to be done? The staffing agency says, we'll send somebody over who speaks their language, who will sit in on the training, or you can, and will assist and answer the questions and translate appropriately the information if it's not being understood. I mean, you're getting the training from the host, and somebody there would be then, if the information needs to be communicated in a proper language, then they will do that. All right. That individual will not be doing the daily supervision of the individual, but he's going to perform administrative duties such as time and attendance records for that staffing employee and taking care of those essential things and making sure that the employee understood what the training he received is. And in some cases, if the person comes and visits once or twice a week to that work site, just to verify that, again, the safety and health of the employee, they're meeting the requirements of what those standards say. They're not directly supervising it, but just understand that. At the work site, the supervisor from the metal can company assigns each of the temporary employees to a particular machine. The supervisor also controls and checks on the employees throughout their shift. On the second day, one of the temporary workers suffers a finger amputation because they were operating an inadequately guarded machine press. Who was responsible for recording the injury? In this situation here, again, this defines that it's going to be the responsibility of Metal Can Company to take that hit on their OSHA log and do, if it's required, notify OSHA within 24 hours that an amputation has occurred, and possibility as a result of that within 24 hours to notify the area office and national office, potentially resulting in an inspection as a result of that incident. Okay. The issue here is, who is responsible for the injury? Again, was the employee properly trained? Answer may be, he was not aware that that guard was missing. He was not informed. You cannot operate this piece of equipment without this machine, this piece of equipment, this guard on there. And again, it comes back to the Metal Can Company's responsibility for recording on their OSHA log and also to do the essential notifications to OSHA in the case of fatality, amputation, hospitalization of one or more people, loss of an eye. All right. Hazard communication. All right. Host employers hold the primary responsibility, again, because they are the users or producers of the chemicals or the products. They have the ability to create and control the hazards. Staffing agencies cannot control the hazards. You have no responsibility. The host employer is best suited to inform the workers of chemical hazards specific to the workplace, as well as physical and other types of hazards that might be present at the site. The staffing agency maintains a continuing relationship with its employees and is at a minimum expected to inform, again, of the standard requirements of the standard, not the specifics. What is required, that the site should have a hazard communication program, and to make sure that they get that information and know how to request that, how to be informed of the hazards, of the materials that they're working with or the operations that they're working with, how they get that information, they get the proper training. Another question comes back. There's many times that a person may be going to a work site and there could be not only safety concerns, but industrial hygiene concerns. The individual could be exposed to chemical hazards, as I mentioned. Some of them are hazards that are covered by OSHA-specific standards. For example, it could be worked as hexavalent chromium, lead, cadmium, noise. In some cases, it might be radiation, may not be the responsibility of OSHA, but it could be under Nuclear Regulatory Commission that they have to respond and address those issues for any temporary employee on site. Must the employee be qualified for use of respiratory protection? If the site says, our people, you have to wear a respirator, can a host employer just give an individual a respirator if you're a staffing agent? If you're from a staffing agency point of view, can a host employer give that individual a respirator? The answer is maybe. What I mean by maybe is that individual has to be certified and medically qualified to use respiratory protection. Whether this is done through physical examination and testing for pulmonary function testing, other types of diseases, or at least through a completion of the respirator questionnaire to identify whether or not the individual may or may not be qualified, or if there's other pre-existing medical conditions that may preempt the individual from wearing the respirator and as a result may require some additional testing. So again, must the employee be qualified for use of respiratory protection? You as staffing agency may receive a request for an individual, for the company to provide employees who could demonstrate when they get to the site that they have a card indicating from a doctor that they are medically qualified to wear respirators. And you may be asked to provide that information. What do you do as far as a temporary agency? If you know you're going to provide employees to a certain location that are going to require respiratory protection, and that's the type of people they want, you may have to contact a medical physician, identify what needs to be done, how best to handle it. Again, it might be just having employees fill out the questionnaire, submitting it to a doctor to give a quick yes or no. Is a person medically qualified? If they answer a question, they have a certain medical condition. Without further examination, he may say, I cannot certify that individual. So again, you may be requested to send a certain qualified employee. Audiometric exams. Person going to work at a company with high noise levels. Person's going to be there for a period of time exposed to high noise. He may have to wear ear protection. Whose responsibility is it to do audiometric testing, to do baselines? In some cases, if you know you're going to be hiring people and sending them to a certain location, the likelihood, it might be the staffing agency. You may want to do that and let the employer know that you have that record. An individual comes in, and then they would then train the individual relative to their hearing conservation program, where they need to wear ear protection, what type of ear protection, show them how to use the ear protection on site. That comes back as a responsibility of the host employer. If a temporary employee is working at a job site and he has a chemical exposure or exposed to a chemical, whose responsibility is it to identify the nature of the exposure? It's not the staffing agency. That is the host employer's responsibility. Whether or not they perform an exposure assessment on that employee or they provide information to that employee relative to a summary of exposure from that chemical, from that hazard, that they have their records for people doing the similar job. This is what the information records are. If they don't have that, and that individual was going to be doing that task, could be lead, could be cadmium, could be benzene, whatever else, they don't have documentation, they may need to sample that individual. It's going to be the responsibility of the host employer. And both the host employer and the staffing agency need to be aware of the access to exposure and medical records. Basically, this is any and all information relative to any records that indicate any health concerns, health exposures, medical evaluations, whatever else. That is the right of the employee, the temporary employee, to be able to request that information of the host employer or of the staffing agency to provide that information, those records to him. Or to, if he signs a proper document, provide that information to an appropriate agent. It could be, if it's a union person, it could be a lawyer to provide that information to him. He gives that authorization to release that to him, then that information will be released. And again, it's for any kind of exposure record, industrial hygiene sampling, noise levels, any potential chemical exposure, nature of chemicals used on site, and some of that be currently being used, or that was used and discontinued. Individual may have worked there. It needs to be maintained for a certain period of time, a minimum of 30 years, or 30 years plus, or after the period of time that record, that employee works there, or for it transfers to a new company who takes over that direct responsibility. Personal protective equipment. Whose responsibility is this? In my viewpoint, if you're a staffing agency, what you need to do is ensure that you make sure that that individual shows up at the plant gate with at least the basic safety equipment that may be required. Ask the host employer what's required so that when the individual gets to the job site, he may need safety glasses. He may need steel-toed shoes. These are basic, basic equipment that he should be expected to come to the job site with. All right? And you should provide the temporary employee. If there is specific non-basic type of PPE that is required, the host employer in some cases needs to specify that, or should specify that, if they want the individual to be on the job site with that equipment, what the person's going to need when they come on site. And that may be the responsibility then of the staffing agency to provide that information, that equipment. This could include flame retardant clothing, cotton clothing. The individual only can wear cotton clothing, can't wear t-shirts, has to wear long sleeve shirts. What is required? The safety shoes. Is there any reason that the individual, does he have to have steel-toed shoes? The answer is yeah. Okay, that may be the basic. But does he need steel-toed shoes with special features, which could be metatarsal support, which could mean have oil-resistant soles on the shoes. The shoes must be electrical resistant. They cannot be conductive. They have to be resistant to electricity and whatever else, enable the person to do the work. That may be a requirement of the job site. Understand, and if that is to be provided, then that's essential, okay, to know that. Welding hoods. If you are sending people out, specifically a staffing agency handling certain people, you may be required to provide, if the person's going to be doing welding, that individual's going to have to come to the job site with the appropriate equipment. That may not be provided by the employer, the host employee. He's going to request that that person comes in equipped with the appropriate equipment to do that job. Once the person's on the job, and if they change what's required to something that's more specific, then that becomes a responsibility of the host employer to ensure that the individual has the proper PPE specific to the work task. It might be a specific type of glove to protect them from exposure, skin exposure to certain chemicals. It may be different type of face protection because they have a different type of job. That's the responsibility then of the host employer to ensure that that person has the same equipment that the full-time employee has. Okay? General qualifications and knowledge specialties. Again, if they're requesting, if a company requests somebody to operate mechanical powered equipment, forklifts, powered pallet jacks, scissor lifts, or JLG lifts, you may be getting a requirement that from the host employer that it's the expectation that the employee that you are sending over to staff the operation fill that position, that individual comes along with the qualifications, a card indicating that he has received and been certified that he can operate the particular equipment that they're looking at. It could be crane operation. It could be, like I said, forklift trucks. He can come with that card or with that documentation But does that mean that that employee then is able to go right to work and operate the equipment? No. Now he has to go back, and the host employer's responsibility would be verifying, number one, have you ever operated this Eaton? We operate Eaton forklift trucks. We operate Mitsubishi, whatever. We use this type of equipment. JLG lifts. The individual may say, oh, I've worked with lifts before, but not JLG. The responsibility would be for the host employer then is to train the individual and make him aware of what the program is at the site, the controls of the equipment, and just verify that he's capable of operating it. He's capable of operating that equipment, but making sure he's operating the specific equipment that he has on the job site. Could be crane operation. A person they want to have, if they're electrical workers, understand lockout, tagout, the energizing systems, how to do that work. What it says when it says confined space, what their requirements may be. The liability and responsibility. In general, the bulk of regulatory responsibility and liability rests with, in the event of accidents or illnesses, lie with the host employer. As I mentioned before, again, it's repeating it. Control of hazardous conditions, chemical exposures is going to be the responsibility of the host employer. Fail to provide the specific PPE that's required for the job beyond the basic requirements will fall to the host employer. And most importantly, to ensure the adherence to procedures such as lockout, tagout, confined space, working at heights, that falls to the host employer. There may be exceptions, again, in some cases relative to training, knowledge, but that is going to be primarily the responsibility if an injury or illness occurs or an event occurs. Primary responsibility is going to be by the host employer, and there may be some shared responsibility and citations and liability to the staffing agency as well, and I'll demonstrate that. This is an example here of a case relating to a temporary worker who was assigned to a job. Company supplied people to work on a job where there was digging, excavation was being performed. Several, maybe 10, 15 feet below ground level. Person goes to the job site, individual goes into the excavation collapses, the individual that the staffing agency has sent over dies. Is it the full responsibility of the host employer? It might be that your staffing agency is sending somebody over to supplement a contractor's employees. Again, he's taking his direct supervision from the host employer. This is a situation here in a case where it demonstrates that you knew that in the type of work that the contractor does, you normally send people to a job site similar to this. As a staffing agency, you failed to properly train and make the person aware of what the requirements were, and you have responsibility because you did not properly train. So again, this is a case in point that you can look at, and OSHA has these published, and you can find these on their website. This is another case showing shared responsibility, and this is a situation here where involving people working at a site which has had previous problems from people working at heights. The site had significant issues with it, fatalities that have occurred that have affected the temporary agency. A fatality had occurred to one of the staffing agency employees. OSHA inspected. Who had full responsibility? Full responsibility was the host company. But the staffing agency also gets liability because knowing full well that the nature of the hazards of that site, you did not do anything to forego any of the potential hazards or make the person aware. As a result, you have liability that you did not properly train and inform the individual as to how to properly do the job and make sure that they were issued the appropriate equipment before they did the work task. Again, these are some other examples that you can look at, and again, you can go back to the OSHA webpage and look at these in detail. This is a standard posting that is expected. If you work through a staffing agency, it specifies by OSHA what the general rights are and requirements to the employee, what the rights of the employee are, and what you are supposed to ensure is being performed, and letting the individual know that if they have a concern, and if you were punished for speaking up about safety or reporting an injury, contact OSHA. But it's telling the employee what his rights are, and basically it's also telling the employer that this individual has these rights. Again, this is the OSHA webpage for temporary workers. Is the webpage. Let me go back. I'm going to go back and bring up this page very quickly. This way. Temporary workers. All right. Again, I just went through the process. When you went to OSHA.gov, you go to, if you don't know what you're exactly looking for, in this case here, you can go to an A to Z index. And in this case here, come down to temporary employees, temporary workers, click on that, and it brings you up to this web page. All right. And again, it talks about what the initiative is. It reinforces that. How can OSHA help? It provides the guidance here, on-site consultation programs. It talks about how to get the information, as I mentioned before. If you have questions, where are you located? Who do you call? If you're in Iowa, who will you call? Can you call national office? Who do you contact in the state of Iowa? Over here, we have highlights. The highlights are, as I mentioned, OSHA has issued policies or temporary programs or bulletins how to respond to certain issues. They have issued 9 such guidance documents, essentially, covering injury illness recording requirements between the staffing agency, identifying responsibilities for staffing agencies and host employers. Again, provision of protective clothing, equipment, whistleblower protection rights, safety and health training, hazard communication, bloodborne pathogens, powered industrial truck training. Goes in detail covering the areas, many of these areas I have identified and said are areas that have joint responsibility, but how does it fall towards a staffing agency, definitively, and to the host employer? This is good information. You also have where the reporting news releases. And what these do here is this will take you to reports, all cases that have involved OSHA citations at job sites where temporary employees were affected. You can look at these and understand the nature of the types of injuries and investigations and whose liability and responsibility and how it's affected a staffing agency versus a host employer. You can look at these and identify, it may be you as a staffing agency have people working at a site. You as a host employer, it may be an operation that you're doing, but it makes you aware of what has been done relative to investigations and inspections and citations issued to sites that have had OSHA issues, inspections. But I just wanted to go back. That is all the information that you will find, again, on that OSHA webpage. On-site consultation programs. This is a situation here where most states will have a consultation service that employers, or mostly small employers, can request an inspection or a visit by people to come out to the site, usually through a state organization, or if it's a state plan, it might be an OSHA-sponsored event organization paid for, where they can come out and do a safety inspection quote unquote, it's a safety inspection voluntarily being requested, there is initially any finding will not be an OSHA citation. You will be notified of a problem at a host site, and take the appropriate action to correct it. In some cases, by going through this process, if you're a small employer, you may be able to get documentation that you've gone through this consultation program inspection and receive a reduction in your workers' comp or other state comp costs. So again, these are some things that you need to look at. Let me go back to the hang on here. All right. Now we're back to the presentation. Enforcement guidance, just covering this very quickly, and I've talked to these before. I'm just going to very quickly, these are the documents and areas where you look at for enforcement guidance, as well as on the web page. Keep in mind, the last one down, as I mentioned, employees' responsibilities towards temporary employees. This goes back to a document or to a letter of interpretation that was issued in 1994. And as I said, if you go back through the letter of interpretations to a lot of standards, there may be references there within those particular OSHA standards relative to, I have a temporary employee on my job site, I have hearing noise problems, or I do this type of thing. How does it affect a temporary employee? And it will respond and give you that answer. Again, these are the temporary guidance policies that OSHA has published that I went over that shows that's on the temporary workers OSHA page. In summary, staffing agencies have legal obligations not only to comply with the requirements that are to only be able to comply with the requirements that are under their exclusive control, but also the need to monitor the working conditions of your employees at the client's work sites, places. I urge that you do this. You have an understanding. If you're a staffing group sending people out and have no awareness as to the nature of the hazards that your people are doing, I think you're doing a disservice to the people. That's my suggestion. I think you need to have an idea as to the nature of the operations. Contact the company if you're frequently sending people there, and arrange for some of your management people or other people to go out and take a look and see what's going on. Understand the nature of the operations. The host employers must treat the employees like any other worker in terms of training and safety procedures. They're your employees, essentially. Even though you are not directly paying them, you provide day-to-day direction and guidance to them. They are your employees. Okay, and again, these are just some general pictures, compliance assistance programs. You'll find this on the OSHA webpage. The on-site consultation programs, I spoke to this. So recommended actions for protecting the workers, again, staffing agencies should evaluate the host employer's work sites. Train agency staff to recognize safety and health hazards. Ensure the host employer meets or exceeds other employer standards. Assign occupational health and safety responsibilities to internal if you're a staffing agency, and define the scope of work in the contract as to the nature of the individuals that you are providing, what their qualifications should be, and ensure that you provide and meet those requirements. And the host employer should, if they change their requirements, let you know as to what needs to be done for the nature of the type of employees you need to provide. Again, it's important. Conduct safety and health training and new project orientation for all temporary workers. Again, primarily the responsibility of the host employer. Detailed, specific requirements for doing the job safely. Agencies need to maintain contact with the workers and maintain an open line of communication between the staffing agency and host employer from the start to the end of the assignments. And in summary, again, staffing agencies have legal obligations, not only to comply with the requirements that are under your exclusive control, but also monitor the work conditions. And again, this is just a repeat of a slide. This is a general reference to a document that came out several years ago by the National Law Review, which talked about several years after the initiative was developed, talked about some of the bulletins and how they can affect the bulletins that they publish relative, like I said, to powered industrial vehicles, hazard communication, hearing conservation, how you as a staffing agency, what your responsibilities are versus the host. All right, to that end, these are just some general questions that, I will put down here I can raise, but hopefully turn it over to you now if you have any specific questions of things that I have said, and I can give you a better, more detailed answer to. So please, at this point, let me turn it back over to, so that you can either ask questions on the phone or through the chat.